Hello everyone, welcome back to Courts Today by LiveLaw. I am Debojit Das and we hope this Diwali was filled with brightness, relaxation and maybe clean air. The law of the country changed and grew today as it does every day, so let's get right into it. We'll begin with what seems like another blot on the Supreme Court Collegium's public perception. In its recent decision to transfer Justice Atul Sreedharan from the Madhya Pradesh High Court to the Allahabad High Court, which has set a worrisome precedent for judicial independence. The Collegium openly acknowledged that the final move, diverting him from the initially proposed Chhattisgarh High Court, was made on reconsideration sought by the government. This explicit admission of the centre's influence in the transfer of a judge known for delivering strong rulings against the executive, such as quashing detentions under the Jammu and Kashmir Public Safety Act and ordering an FIR against a sitting MP minister, is highly troubling. Critically, this transfer also damaged his professional standing. He went from being the likely second most senior judge in Chhattisgarh to the seventh in Allahabad. The lack of documented reasons for abandoning the original recommendation suggests that the executive is dangerously eroding the Collegium's autonomy over judicial transfers. Moving on to another important story coming in from the top, as the Supreme Court delivered a powerful assertion of bodily autonomy and dignity for transgender persons, unequivocally ruling that they do not require their employer's permission to undergo sex reassignment surgery. This ruling was made in the context of the petition filed by Jane Kaushik, a trans woman teacher who was unjustly dismissed by two private schools, one in UP and one in Gujarat, solely because of her gender identity. The bench of Justices J.B. Pardiwala and R. Mahadevan found this discrimination appalling, noting the union and state government's grossly apathetic attitude. Consequently, the court ordered significant compensation, Rs 50,000 each from the Union of India, the state of Uttar Pradesh and the state of Gujarat for their regulatory inaction, plus an additional 50,000 rupees from the second school that denied her employment. Beyond the compensation, the court affirmed that the right to self-determination of gender identity is a fundamental right which is integral to Article 21 of the Constitution. Next, we stay with the Supreme Court as it firmly reiterated that the Hindu Succession Act does not apply to members of the scheduled tribes, striking down a directive from the Himachal Pradesh High Court. A bench of Justice Sanjay Karol and Justice Prashant Kumar Mishra set aside the High Court's sweeping direction that daughters in the state's tribal areas should inherit property under the HSA rather than customary tribal laws. The Apex Court held that this directive was contrary to Section 2, Subsection 2 of the HSA, which explicitly states, "Nothing contained in this Act shall apply to the members of any scheduled tribe unless the central government by notification otherwise directs." The court noted that the High Court's intervention made to prevent social injustice and exploitation was unwarranted because the issue was not framed or argued in the original appeal. Relying on the precedent set in Tirath Kumar versus Daduram, that is of 2024, the court reiterated the legislative exclusion of STs from the Act. While the court had previously urged the Parliament to amend the law to extend the HSA or the Hindu Succession Act to STs, it confirmed that as the law currently stands, customary tribal laws govern succession. Moving on to our next story, as the country's capital saw the Delhi High Court concluding a 25-year-long trademark battle between confectionery giants Mars Incorporated and Cadbury India over the use of the word celebrations. The dispute centered on the use of the mark celebrations for assorted chocolate and confectionery boxes, which Cadbury has prominently used for its popular Diwali assortment. Mars had filed a suit in 2018 against Cadbury for trademark infringement, in addition to pending opposition and rectification proceedings before the Trademarks Registry, challenging Cadbury's application for the mark. The legal contest was resolved through mutual settlement between the two companies. In a truly unique closure, Justice Sanjeev Narula decreed the suit, and as a symbolic act of harmony and goodwill, ordered both corporations to distribute sealed units of their confectionery assortments to school children enrolled in government and government-aided schools in the National Capital Territory of Delhi, preferably before Diwali. This gesture marked an amicable end to litigation that had consumed judicial time for nearly a quarter century. Next, towards the south, the Kerala Sessions Court has granted anticipatory bail to Congress councillor Joseph Franklin, the General Secretary of the Thiruvananthapuram DCC, and a Neyatankara municipality councillor who was booked in a severe case involving sexual harassment and abetment to suicide. The prosecution alleged that Franklin, under the pretext of arranging loans and a municipal subsidy for a woman's new bakery, sexually harassed her, made sexual overtures, and attempted rape at his office. This continuous harassment allegedly led the victim to commit suicide by setting herself on fire after leaving a suicide note. Franklin was charged under the BNS for offences including sexual harassment, that is section 75, attempt to commit rape, that is section 64, and amendment to suicide, that is section 108. Despite the fact that the petitioner had criminal antecedents, the Sessions Court granted him pre-arrest bail. The court noted a lack of prima facie material for the sexual assault allegations apart from the suicide note, which also allegedly directed the de facto complainant to blackmail Franklin. The court concluded that the question of abetment can only be decided on the merits at trial. And coming to our final ruling, the Madras High Court recently delivered a landmark ruling affirming that the Juvenile Justice Care and Protection of Children Act of 2015 prevails over Muslim personal law in matters of child adoption. The case involved a Muslim man who challenged the registering authorities' refusal to register an adoption deed after he adopted his deceased brother's child. Justice G.R. Swaminathan noted that although Islamic religion does not traditionally recognize adoption, the Juvenile Justice Act, specifically sections 1, subsection 4 and section 63, read with Article 15, clause 3 of the Constitution, provides a secular statutory framework for adoption for all willing parents, irrespective of their religious background, a principle established in Shabnam Hasmi versus Union of India. The judge declared an adopted child will have the same status as that of a biological child in all matters, and an adopted child cannot be given a second-class status. While the petitioner was a Muslim, the court held that they must follow the stringent process laid down in the Adoption Regulations 2022, which involves the district magistrate, rather than simply registering a deed, ensuring the adoption serves the child's welfare. And before we wrap things up, we have to take note of the inaugural Professor G.N. Saibaba Memorial Lecture, where former High Court Chief Justice Dr. S. Muralidhar characterized the state of academic freedom in India as severely restricted, where judicial processes have become the punishment. Justice Muralidhar highlighted that India's global ranking for academic freedom has plummeted to the bottom 10 to 20% of countries, reflecting a current environment where dissent is suppressed and ideological pressures dominate. He starkly pointed to Professor Saibaba's case, where the process of over 10 years of incarceration under the UAPA ultimately broke him, asking who will be held accountable for what the system did. He cited other cases, including a professor being booked for keeping an alleged Hindu-phobic book in a library as evidence of a virulent form of totalitarianism, supported by repressive laws and the control of mainstream narratives, warning that social divisions exacerbated by caste and communal prejudices threaten the constitutional value of the spirit of inquiry. That was all on Courts Today. Remember, to access India's most credible and consistent source of legal reporting, visit www.livelaw.in and follow us on all our socials to stay updated with everything that is law.